Mama Kwabam from like Black Media. Abuja vacancy ho sensema down ho gina anase gina ho ntre ha ewo ye o my Ghana for vacancies na ene MPP for etable asem yi edikopie mu ewo Supreme Court no. Abuja ene Speaker of Parliament Parliament o matna asem no so biem na abuja yase se winimu mra emne new enti Speaker of Parliament aberewa bebesie Alban Bagbin wase me se mahu se ya twade ne pa wo Ghana mra mu die there is no way say Chief Justice Gertrude ebeka bibia matiase na o kasa no se me kire ama Ghana fo na hu se me mesua de na minimade pa afei Chief Justice ani Judicial omudi hu dwumani na so omabonwa obi antumrika na onkofa na 1992 constitution na womie enko article 115 article 115 ni tia we na ne se Speaker of Parliament ehemra efa vacancy ho nsensem a tumi bia ni hono ma wo Ghana ekere se ebetimi atwea wo from ene including Supreme Court Judicial bia ni hono ma ebetimi atwea no de awo from afi oka article 97 no so krampo kire se vacancy nkunya bi ba beto honom na nipa na wo se wonye wonni party na nimu bimu no so MPP ni o NDC ni o na amana ba power no so afi wontimi ni akire bimu a kwa wo se seat ni da honom kopem se beto aba ene no ne saa no enipa dodo a ye bekan a omo bedoso e wo mrehye bedwafie no omo ene beye majority eti adai ena still na judicially omo so omo ntiase ene wo wie no wode na no nsemo ba wie se ya Gertrude wa ye bone papa in fact wa ye bone na judicially ene Chief Justice monko pa cha opansere emfa emma o my Ghana na afenso ayemrehye bedwafie se monim no kula na mwanka na madi mo ho yaw ene wakasa bebre kame ho yenkwaje nchiremu no mra sisie
had to cater for such a government by a number of provisions in the standing orders. We also provided provisions for all the other options of government that I just explained. For instance, a day which we call a decision day has been designated in the new standing orders, where the Speaker, in consultation with the leadership of the House, will set aside to allow members of Parliament who are ministers and deputy ministers the opportunity to be present in Parliament to be counted in support of government position to ensure government business does not suffer for lack of government members of Parliament in Parliament. Despite the above, often the number of government members present still don't add up due to the nature of the duties and responsibilities of ministers and deputy ministers. The NDC members of Parliament, however, understood the situation and on a daily basis cooperated with the MPP members of Parliament to see government business through. In spite of this, the NDC members are said to be saboteurs of government business by the MPP members of Parliament and the followers of the new patriotic party. Those of you who cover proceedings on daily basis are witnesses as to how sometimes I have to look at the members of the NDC in a very stern manner, which made them give in to their objections, just to get government business going. Ladies and gentlemen, the powers of the judiciary ends where the nose of Parliament starts. The Constitution is very clear on freedom of speech and of proceedings of Parliament. Articles 115 and 116 grant members of Parliament privileges and immunities of speech, debates, and proceedings on any matter or thing brought by a member in or before Parliament by petition, bill, motion, or otherwise. I want to quote the two articles to you. Article 115. There shall be freedom of speech, debate, and proceedings in Parliament, and that freedom shall not be impeached or questioned in any court or place out of Parliament. Article 116. Subject to the provisions of this article, but without prejudice to the general effect of Article 115 of this Constitution, civil or criminal proceedings shall not be initiated against a member of Parliament in any court or place out of Parliament for any matter or thing brought by him in or before Parliament by petition, bill, motion, or otherwise. This means happenings in Parliament must remain in Parliament. So the court must and has always been hesitant to interfere in the proceedings and decisions of Parliament. In the celebrated case of Tufor versus the Attorney General, the Supreme Court affirmed that happenings in Parliament are a closed book. Despite these provisions, the courts are replete with debates and proceedings of Parliament. Most worrying is these proceedings are initiated by some members of Parliament, even leaders of Parliament, who ought to know better. Parliamentarians who are to be loyal to Parliament rather than to the Supreme Court run to the Supreme Court at the slightest opportunity to use the Supreme Court to undermine Parliament. This might be one of the reasons Parliament and members of Parliament are not respected and treated with disdain. This was exhibited by the President's refusal to even receive the LGBTQ+ bill, duly processed and passed by Parliament without any legal basis. The judiciary is supportive of this conduct by the receipt and processing of a suit on this subject matter. These are dangerous precedents in our democratic journey. Both the President and the judiciary have sinned against the Constitution and must seek the opportunity to confess and repent to be forgiven. I am confident the battles we are fighting today will make our democracy stronger and more vibrant in the future.